Ladies and gentlemen, may I ask you to take your seats? We'd like to begin the program. I'm Lori Damrosch. I'm the president of the American Society of International Law, and it's my great pleasure and honor to welcome you to the opening event of our 109th annual meeting. It's been a tradition now for 17 or so years that we open our annual meeting with the Grotius lecture, so graciously hosted by the American University Washington College of Law. And I will soon be handing the microphone to Dean Claudio Grossman of American University, who will be introducing our speakers. But since I've known the speakers for a pretty long time, I just can't resist saying a couple of words about them in my own voice. And I'm just going to summarize it by saying 2 or 3 or 4 50s. So if you have opened your hard copy of the annual meeting program, you'll see a welcome message from the president in which I mentioned that when we informed Judge Sir Kenneth that he would be this year's honorary member selected to come to the American Society of International Law annual meeting and given this honor, he said, it's going to be 50 years since I attended my first annual meeting. And that's because he attended as a student, as we hope many of you are. And he was undoubtedly a very youthful student. He got on a Greyhound bus and took the bus from Harvard Law School down to Washington to attend the 1965 annual meeting. So that's our first 50. And the second 50 is Dame Rosalyn Higgins. She told me not to mention this. And I said, I hate to make her uncomfortable, but it was already in what I planned to say, and I just have to say it. Tomorrow, at our annual general meeting, to which all members of the society are invited, she will be designated a member emerita, meaning that she has been a member of the American Society of International Law for 50 years. And that's because she also joined as a student. She joined, I think, were you a graduate student at the time, or were you a kindergarten student? She was either a graduate student at Yale, or she was interning in the Office of Legal Affairs at the United Nations, working at the time for Oscar Schachter. And after Oscar Schachter passed away in 2003, and I came into custody of his papers, I found the letter of recommendation that she had written for her on the outbound from his office, in which he said, I am very confident that she will complete her fellowship project on time and that she will go on to great distinction in international law. And we know that that is true. So those are my 2 50s, and the third and fourth 50s are that 3 years ago, 3.5 years ago, I guess, almost 4 years ago, this is getting embarrassing, I was inducted into the Institut de Droit International in its session held in Rhodes, and we celebrated the joint 50th wedding anniversary celebrations for Kenneth and Jocelyn Keith and for Terrence and Rosalyn Higgins. So the 2 Keith and Higgins couples, I don't think that they knew each other 50 years ago, especially since I said that they were married as children, right? Maybe it wasn't the same prohibition that we have in international law now on age 18 is the age of consent. In any event, those are my 3 or 4 50s. And it's now my great pleasure to introduce Dean Claudio Grossman of the American University Washington College of Law. He's a very inspirational leader of that law school, which of course has signature programs in the field of international law, international humanitarian law in particular, and international human rights, in which he is quite a leader from the perspective of the Inter-American Commission and the organs of the Inter-American system in the first instance, and then for quite a few years now with the Committee Against Torture of the United Nations, to which he has been elected in 2003, and then elected as chair, and then re-elected as chair, and then re-elected as chair, and last year he was just re-elected to an unprecedented 4th term as chair of the Committee Against Torture. So this gives me the opportunity also just to put in a little plug, since you may not have seen, since it all just fell into place last weekend, that our Saturday closing plenary is going to be on the subject of torture, and Dean Grossman will be one of the panelists. So this is just a little reminder to you, check all your program updates so you'll know the things that have been added to the program since the time that the printed program was prepared, and please do join us on Saturday for that plenary session. And Dean Grossman will now introduce the speakers.
Thank you, Lori. Let me start by saying that it's a good training to be in the Committee Against Torture, to have a faculty meeting once per month. Also, let me alert you that I just came from a trip to Latin America and I pick up this accent that it most likely is going to get worse as things continue. Well, good afternoon, everyone, and welcome to a 17th annual Grotius lecture, which began as a partnership between American University, Washington College of Law, and the American Society to present important voices on vital issues in international law. And you know that anything that happens in the nation's capital more than once becomes a tradition. And we never thought that this tradition will go so many years. And I think it touched a very important fiber, the need to take a look at fundamental issues facing and challenges facing the international community. And we thought that nothing was better to represent that than to name this series Hugo Grotius, or Hugo de Groot, and so forth. He captured the spirit of his time by identifying norms and principles capable of providing the legitimacy that law gives to decision-making in the realm of international relations. And his ideas, or most of his ideas, paved the way for international law to evolve into the system we know today. Grotius created a system of norms that attempted to regulate international law as a whole, establishing paradigms of the legal system. We cannot think of better speakers to discuss today's topics, some thoughts about Grotius 400 years on, than the 2015 Grotius lecturer, Sir Kenneth Keith, former judge of the International Court of Justice, and the distinguished discussant, Her Excellency Dame Rosalyn Higgins. Sir Kenneth Keith and Dame Rosalyn Higgins are well-renowned authorities who follow also a very distinguished group of speakers who have occupied this podium, embodying to the commitment of law in international relations. Prior Grotius lecturers included Radhika Kumaraswamy, then UN Secretary General and Special Representative, Under-Secretary General, Special Representative of the Secretary General for Children and Armed Conflict, the then ICRC President Jacob Kallenberg, the Harvard professor and Nobel Prize winner Amartya Sen, the University of Utah professor Anthony Ng, Achim Steiner, Executive Director of the United Nations Environmental Program, and the Jordanian Prince Saeed bin Riyadh, currently the United Nations High Commissioner for Human Rights, among others. What they have done is to contribute collectively to our thinking in international law. Now, Sir Kenneth Keith served on the International Court of Justice from 2016 to 2015, following a distinguished career as a lawyer and judge in his home country, New Zealand. You can read more about his impressive contribution to the ICJ and in New Zealand in today's program materials. Let me briefly add that Sir Keith is widely published in international and public law. His scholarship covers a wide variety of topics, including, but certainly not limited to, New Zealand law, domestically and how it intersects with international law, international treaty law, international maritime law, human rights, victims of armed conflict, the International Court of Justice, United Nations law, nuclear testing, sovereignty in the 21st century. Dame Rosalyn Higgins served as a judge on the ICJ for 14 years, including as president from 2006 to 2009. She's currently president of the British Institute of International Comparative Law. And also you can read more about her illustrious career and contributions in today's program material. Let me add that the depth and breadth of Dame Higgins' legal scholarship is impressive and covers a wide variety of topics as well, including legal theory, humanitarian law, natural resource law, human rights, United Nations law, the use of force, and state immunity and diplomatic immunity. While the views of our lecturer and Discussant are always highly relevant on any topic of international law, their learned views are particularly important in today's world, where we see serious challenges to a normative regulation of matters such as peace, security, the proliferation of weapons of mass destruction, the enforcement of human rights, the environment, to mention a few ones. We're witnessing, as a result of these challenges, the emergence of behavior and voices that question the authority of international law and ultimately its underlying paradigms and the relevance of international law to the conduct of international relations. Without further delay, please join me in welcoming the 2015 Grotius Lecturer, Sir Kenneth.
Well, thank you very much to the Society and to the University for this opportunity to address a rather large topic. What would Grotius see as major challenges for international law and its practitioners in our time? How would he approach those challenges? How would he balance beautiful theory and ugly fact, heritage and heresy? What lessons does he teach us in dealing with our tasks today? As has already been indicated, and as my abstract indicated, I'll be looking back 50 years as well to that first visit to this great meeting. In the course of the last 50 years, and slightly more, I've been an observer and occasional participant in the application and development of international law in the face of major change and challenge, to refer to the theme of the conference this year. I will keep returning to matters of the law of the sea, and I first really seriously addressed them in 1960, when I began as a junior lawyer in the New Zealand Department of External Affairs, right at the time that the second United Nations Conference on the Law of the Sea was convening. It will be recalled that that meeting narrowly failed to adopt a provision for a 6-mile territorial sea and a further 6 miles of exclusive fisheries zone. New Zealand, a few years later, did extend its fisheries zone to 12 miles from the coast. That was challenged by Japan, which suggested that the matter should be taken to the International Court. New Zealand demurred, and an agreement for a phase-out of Japanese fishing was adopted. There were already, of course, much more extensive claims, particularly the 200-mile claims to a patrimonial sea made by Chile, Ecuador and Peru, and the practice relating to the continental shelf was developing apace. Now, I'm just going to say a few words about Grotius, to go back another 350 years from the time I was talking about. If we go back, and I apologise to those for whom some of this will be very familiar, but I think a bit of background is helpful. If we go back 400 years, we find Hugo Grotius addressing law of the sea issues as counsel for the Dutch East Indies Company in the Admiralty or Prize Court in Amsterdam, in a dispute arising from the seizure by a company ship of a Portuguese galleon in the Straits of Malacca. In 1613, Grotius was in London negotiating in Latin with James I of England and James VI, was it, of Scotland. James didn't have a Secretary of State. They negotiated directly about fisheries and much broader matters of trade in the East Indies. And he was back again in London in 1615, negotiating about whaling around Spitsbergen. So a lot of matters that continue to arise. He was already a renowned author as a theologian, and he was an accomplished poet. But from that time, it is his treatise on the law of prize, De Jure Praede, or rather one chapter of it, that's relevant for my purpose. This treatise was prepared as a brief for the company, and the famous chapter, Mare Liberum, the Free Seas, was published anonymously in 1608 and was actually used by the English in the 1613 negotiations. They quoted from the writings of the Asserteur Maris Liberi, taking a passage from the last paragraph of Chapter 8 to the effect that the freedom of trade is based on a primitive right of nations, which has a natural and permanent cause that is part of the law of nature, rather than the positivist law of nations. The argument may also be made that the legal understanding which Grotius gave to the role of the Dutch East Indies Company facilitated the voyage made by Abel Tasman, one of the company's captains in captaining the Heemskerk and the Zeehan, 35 years later around the west and southern coasts of Australia, across what is now the Tasman Sea, and the first discovery and mapping by a European of New Zealand. The Dutch also managed to name the country in such a way that we sit next to the Netherlands in English alphabetical order in international meetings. I'm not sure that any other discovery or colonial power has quite succeeded in doing that. So by the time Grotius was 30, he'd already prepared an important work on international law of large continuing influence. Professor Ernest Nice, a very early honorary member of the Society, declared in this battle of the books, Grotius had the better of John Selden, his English antagonist. Grotius has second undertaken work as an advocate. Third, he's been appointed to 2 major offices, public offices. Fourth, he's had a major role in diplomatic negotiations, although some question just how effective he was in that. When we look across all of that work, it is the writing of Mare Liberum that is by far the most important for international law and international lawyers. It has tended to be taken as an independent scholarly work, when in fact it was, of course, as well, perhaps you might say, a brief for the Dutch East Indies Company. Now, many of you will know about the remaining 3 decades of Grotius's life. They had amazing twists and turns. In high office, as I've mentioned, in politics and religion, as a person accused and convicted of sedition and sentenced to life imprisonment, his study and writing in the Castle of Lowenstein for 2 years, notably his introduction to Dutch jurisprudence, his escape in a book box, his time in Paris and Hamburg, and his 10 years as ambassador of Sweden in Paris. But it is his de jure belli ac pacis that is the immortal part of him, or at least the major part of that immortal part. Its continuing immeasurable impact flatly denies his last words which he uttered, it seems, in despair. Grotius said, "By undertaking many things, I have accomplished nothing." In his prolegomena to that great work, he said that devotion to study and private life was now the only course open to him, given that he had been undeservedly forced out from his native land, which had been graced by so many of his labours. He was now contributing, he said, somewhat to the philosophy of law which previously in public service he had practised with the utmost degree of probity of which he was capable. One message, I think, which the life of Grotius and many more international lawyers you can think about, one of the message that he teaches me is about the value of changing hats, of having time as a scholar, as a practitioner, private and public, in law reform work and in litigation, as counsel or arbitrator or judge. The whole is other than the sum of its parts. A related second message is that it may well be that scholarly work, or very good scholarly work, will last the longest. I stress may in that sentence, but recall Oliver Wendell Holmes' marvellous reference to the secret, isolated joy of the thinker, that 100 years, and I'm talking about 400 now, that 100 years after the thinker is dead and forgotten, people who have never heard of him will be moving to the measure of his thought, the subtle rapture of postponed power. The example shown by Grotius also makes the point about the importance of governments having good lawyers. Good legal work should structure and complement good public policy advice in the public sector. What do I see in that writing that is of enduring value in addressing the challenges the world faces today? I will have to be very selective. Grotius, in the Prolegomena, while acknowledging his predecessors, especially Gentilis, says that he is the first to treat the whole of the argument. His topic, he says, is the law which governs the relations of several peoples, or rulers of peoples, whether derived from nature, established by divine ordinance, or introduced by customs and tacit agreement. The enduring influence of great scholars who treat the whole of a body, in this case of international law, is not measurable, but I'm sure that it is the experience of many of us that the understanding of a particular matter may be greatly enhanced if we step back and take a wider view and try to see the particular matter in its general context. That is my third message from Grotius. To move away from international law for a moment, when I was considering in my earlier judging life the concept of property, and in a particular New Zealand statutory context, William Blackstone's commentaries on the laws of England from the mid-18th century, notably Blackstone's structure, helped me and counsel well along the way and to see the particular in context. His books were Rights of Persons, Rights of Things, Private Wrongs and Public Wrongs, and you can do a similar exercise on the parts and the books in Grotius's work. That structuring role is hugely important, it seems to me. Now, the other matter which Grotius emphasises at the outset goes to substance, to a central issue of any legal system. It was most certain, he said, that there is among the nations a common law in force regarding war and in war, the right to war and obligations in war. But, he said, I saw prevailing throughout the Christian world a license in making war of which even savage nations might be ashamed, recourse being had to arms for slight reasons or none, and when arms were once taken up, all reverence for divine or human law being thrown away, as if men were thenceforth authorised to commit all crimes without restraint. That common law of jus ad bellum and jus in bello, and his vigorous differentiation between just and unjust wars, to return to his more general formulation and to the full title of his treatise, was to be found in the law of nature and of nations, as well as the principal questions of public law, by which he meant constitutional and criminal law. He did not draw fine lines between international law and national law. A fourth lesson here is, of course, that the law controlling resort to armed force should not be seen as recent, dating, say, from 1928. Hersch Lauterpacht, if I can turn to another great name, in his outstanding article entitled The Grotian Tradition, building on the first brief passage I've quoted and on much more besides, lists as the first of the treatise's principal and characteristic features that the totality of international relations, thinking of something which the Dean just said, is subject to the rule of law. That is the fifth lesson I draw. Similar statements have been made by the United Nations General Assembly, for instance, in its recent declaration on the rule of law, nationally and internationally. But what does that mean in a practical sense? To take one central matter, if the state is subject to the international rule of law, should it not also be subject to the processes of compulsory third-party settlement, as has increasingly been seen in national legal and constitutional systems, as immunities are stripped away from the state? Or should states at least not make better use of the existing processes than they do, even if the processes are voluntary? What are the reasons for the refusal of or reluctance to accept jurisdiction in advance or to make use of settlement methods on a voluntary basis when a dispute arises in a legal system which in substantive terms may now be seen as a rather mature one. If a text has been carefully negotiated and agreed to, or if principles and customary rules are widely accepted, what reasons are there for resisting binding third-party procedures? Almost 30 years ago, even before the end of the Cold War, Grigory Tunkin, the great Soviet theorist, could not see any good reason for opposing such procedures in the treaties that were being negotiated at that time. And if states are so reluctant to accept such procedures, why do they try so hard to have their nationals elected to the ICJ and other tribunals? Do they assess with equal diligence the qualities of other candidates for election? I take as a prime example of better implementation the law of armed conflict, or IHL, one of Grotius's major concerns, as indicated in the passage I quoted a moment ago. Over many years, the better implementation of that law has been at the top of many people's agendas. The very first Geneva Convention of 1864 required governments to give instructions to their commanders-in-chief to implement that convention in accordance with the general principles set forth in it. At the 1974-77 diplomatic conference, which adopted the 1977 additional protocols to the 49 conventions, it was the subject of extensive attention concerning the enhancement of protecting powers, the role of the International Committee of the Red Cross, as discussed a couple of years ago by Jacob Kallenberger, better dissemination and training, provision for legal advisors, new grave breaches, new prohibitions on reprisals, inquiry with the establishment of the International Humanitarian Fact-Finding Commission, state responsibility, and meetings of the state parties. A huge amount of effort then to enhance implementation. If I come forward from the mid-70s to 2003, the states parties to the Geneva Conventions and the national societies at their international conference of the Red Cross and Red Crescent declared that year their conviction that the existing provisions of IHL form an adequate basis to meet the challenges raised by modern armed conflict. That was a direct rejection of the proposition, which had been heard frequently around that time, that the conventions were obsolete and quaint. What was missing, declared the conference, was better implementation. The conference recalled the responsibility of states to respect and ensure respect for the Geneva law. And if I could just mention one aspect of the drafting history of the sentence I've quoted, at one point the draft would have said, the version would have said that in general the existing provisions formed an adequate basis to meet the challenges raised by modern armed conflicts. That qualifier was removed, the statement became more absolute, and it was the United States delegation in the vanguard of those who wanted the qualifier to be removed. Now, the conference, in terms of implementation, called on states to make use of existing mechanisms such as the Protecting Powers and the International Humanitarian Fact-Finding Commission, calls which are also regularly made by the General Assembly, but without any appreciable concrete effect, as a number of us in this room can testify, having been members of that commission and having tried on many occasions to have matters referred to it. The latest attempt at improving implementation is being undertaken by the Swiss government and the ICRC, aimed at a text which is to be considered at the 4-yearly international conference later this year. I do not get the sense from the published records of the meetings of those involved that major improvements will occur. Raw sovereignty raises its ugly head yet again, but I'd be glad to be shown to be wrong on that. Would not Grotius, 400 years on, be surprised by the continued emphasis on sovereignty in such an interdependent world, and be surprised that nationalism is back? I might mention here that in 1949, the conference which adopted the 4 conventions recommended that States consider using the International Court of Justice to resolve disputes about compliance with the conventions. Such disputes are often the subject of reservations by those states which have accepted the court's jurisdiction under the optional clause, and it has been said, for instance, after the Cuban Missile Crisis and in the commentary following the Nicaragua case of the mid-80s, that such matters are not justiciable. Dean Acheson said at this meeting quite some years ago that the propriety of the Cuban quarantine is not a legal issue. The law simply does not deal with issues of ultimate power. But consider to the contrary the various cases in the International Court of Justice relating to nuclear weapons, the cases about armed conflicts in the Great Lakes, the Pakistan POW case against India, aspects of some of the cases from the Balkans, the Iran-US aerial incident case, and decisions of the Ethiopia-Eritrea Tribunal. Or at a more general lesson, the rejection of reason of state as a limit to obligation, a rejection by Grotius of reason of state, which, as Lauterpacht notes, is achieved without a single reference to Machiavelli. In considering implementation, we should not forget implementation through national processes, which, after all, day by day undertake the task, particularly in mundane or normally mundane areas such as trade and communications. We've just benefited from the communications part in terms of aircraft getting us from Wellington to this city. And that happens for thousands, millions of people all the time. And think as well in terms of more serious matters of piracy and war crimes trials in a number of countries, including at the moment in the former Yugoslavia countries and as well in Rwanda. The national processes then have a significant role in all of this, and when I spoke at this meeting a couple of years ago, I referred to an old New Zealand case decided in the 1870s in which the court, having been referred to, not to Grotius, but to Vattel, to Phillimore, to Kent, to Story, decided that on the high seas only the flag state had exclusive jurisdiction, a decision which was not brought to the attention of the Permanent Court of International Justice in the Lotus case when it went the other way and was, of course, reversed by treaties. Now, it'd be wrong for me to give the impression that I'm gloomy about the prospects of third-party settlement of international disputes. Dame Rosalyn and I are evidence, I can give you chapter and verse, of the number of cases that have been dealt with by the Hague Court in the last few years. And so that's a much more positive figure. Now, improvements can be made to enhance the roles of international courts and tribunals. I spoke about that a few months back and I won't revisit it, but I take just one recent set of processes to illustrate a point which Lon Fuller made at this meeting quite some years ago. Choose your appropriate instrument. A sledgehammer, he said, is good for driving stakes. It is not all that good for cracking a walnut, and it's hopeless as a can opener. Some of you will have enjoyed his classes many years ago. The particular matter is also to be related back to Mare Liberum, since it concerns the absolute freedom to fish on the high seas. Grotius based that freedom on the inexhaustibility, as it was seen then, of high seas fisheries. The open sea was to be contrasted with rivers in respect of navigation as well. He based that freedom on that fact of nature, on many authorities assembled by a Spanish jurist, and on the inadmissibility of prescription or custom or express law to defeat such a freedom. But the facts have long been different. Fisheries are not inexhaustible. John Maynard Keynes has an apt comment: when my information changes, I alter my conclusions. What do you do, sir? So there I think you would have Grotius agreeing, and you have a sixth lesson if you're keeping count. My example of well-designed processes for the ongoing management of fisheries, as well as the settlement of disputes relating to them, comes from the South Pacific Ocean. The fisheries in that area have long been under serious threat. Some species were protected in some degree, but until recently there was no overall management regime. In the course of the last decade, the South Pacific Regional Fisheries Management Organisation has been established. In the preamble to the treaty, to the convention, the parties expressed their commitment to ensuring the long-term conservation and sustainable use of the fisheries resource in the South Pacific Ocean, and in so doing, safeguarding the marine ecosystems in which the resources occur. The parties and the institutions they create are to apply a precautionary approach as well as an ecosystem approach. Those two approaches are broadly defined in the Convention. Grotius would, I imagine, have been intrigued by the use of the word approach as opposed to rule, principle, or even standard. And he would be interested, I think, in the cautious attitude of the International Court to that matter. In the drafting of the Convention, procedures were established for the fixing on an annual basis of the total allowable catch and the quotas available for particular fishing countries. The procedures emphasise consensus, but they do allow for majority voting if consensus cannot be obtained. States could object on prescribed grounds, and a dispute settlement process, which was to operate expeditiously, was set up. I should introduce another element into this picture. When the negotiations were underway, Peru brought international court proceedings against Chile for the delimitation of their maritime boundary. There was nothing in the record before the court to show that oil was an issue. Fisheries were in part covered by existing arrangements, and although not mentioned, the South Pacific Convention was being negotiated. There were security and customs interests, and there was, of course, also the long history running back at least to the War of the Pacific, well over a century ago. The court delivered its judgment in early 2014, more than a year after the end of oral argument, the longest period in my time on the court. What, you may well ask, was the real purpose of the Peruvian application? I can make a guess, but judges often can do no more than speculate about the background to and the reasons for litigating. The judgment was given on the very day the second meeting of the Management Commission began the task of fixing the quotas for the next year. In the meantime, the Russian Federation had challenged a measure adopted at the first meeting, a challenge which was heard on the Monday in a hearing in the PCA in The Hague, and the ruling in which was delivered on the following Friday by a panel chaired by a former editor of the American Journal. You might think in Fuller's terms that Bernie Oxman and his colleagues were operators of a very clever can opener, to go back to Fuller. A seventh lesson then is to look across the range of possible processes which are available or which may be invented. I add again the caution that available methods may simply be ignored, and the success so far of that particular process of management and of one instance of dispute resolution must not be allowed to disguise the rapid depletion of many fish stocks. The definition of success may be too narrow. The earlier collapse of the jack mackerel fishery stock in the South Pacific provides one spectacular example among many. The recent development and application of the law of the sea highlights another central characteristic of Grotius's writing, his sources, the law of nature and of nations. The first once dictated freedom of the high seas and freedom of fishing, but in fact new fishing methods no longer accorded with the principle, and new oil extraction technology helped generate the principle that the land dominates the sea and the principle of the natural prolongation of the land territory into and under the seabed. Those principles of nature, which many would question as scientifically accurate, certainly in the case of the first, have become principles of law. I used to puzzle about the proposition when we were in The Hague about the land dominating the sea, when most of the places I visited around The Hague were actually below sea level. and there was all the talk of climate change and so on. And after all, when you look at the globe, there is a huge amount of ocean out there compared with land masses. But that's the principle that has been established as a principle of law. Delimitation between contiguous and opposite states takes account of such principles, but the treaty law, the 1982 Convention on the Law of the Sea, the law of nations in Grotius terms, speaks only of an equitable result. No real criteria for reaching that result are identified by the Convention. The negotiators were simply unable to agree. Many, including members of the court, have been critical, even scornful about the law on delimitation as stated in the Convention and developed by the court in the earlier period. In 1982, one of the judges who had undertaken extensive scholarly and diplomatic work on the law of the sea declared that the court in its judgment of that year appeared simply to suggest the principle of non-principle, a criticism he repeated 3 years later in a further dissent. The headings in his opinion, in that later opinion, give you a sense. Misconceptions in the present judgment, misconstruction, misapplication, maladjustment, and misunderstanding. In the earlier case, another judge, having decided that the judgment did not provide a just solution and had strayed into subjectivism, added a further point by concluding his dissent in this way. For the past 10 years or so, states have been less and less inclined to present themselves before the court. When they have chosen voluntarily to come, the court must answer their request and declare the law, not attempt a conciliation by persuasion, which does not belong to the court's judicial role as long ago defined by the court itself. Now, those grim forebodings and criticisms have not been realised. There have been a steady stream of delimitation cases continuing to come to the court to take the narrower point that was being made by those judges, including 4 in my time from the Pacific, the Caribbean and the Black Sea. Another 3 have been filed in just the last 18 months. More broadly, the court has dealt with many more cases in the 30 years since those statements were made than in the preceding longer period. The criticisms of those judges about the lack of principle and the failure of reasoning in the delimitation cases have also not been realised. The court has developed robust methods which in practice have led to broadly accepted, indeed largely unanimous decisions, with the ad hoc judges concurring. The last words that Dame Rosalyn delivered from the International Court in February 2009, if I've got the arithmetic right, were to the effect that the decision was unanimous and there were no separate declarations or opinions, with a note of triumph which doesn't turn up in the pages of the law reports. So we have then a well-established body of law developed by practice, developed by the court, and it was recently applied by the International Tribunal on the Law of the Sea in the Bay of Bengal case. So an 8th lesson, you might think, is to attend carefully to the interaction of principle, rule and facts, especially the facts which may in the end be decisive. Now, many matters on the international agenda today would strike Grotius as requiring close attention by international lawyers and others. The threats posed by nuclear weapons, climate change, pandemics and natural disasters, the gross breaches of human rights, the work being done within the UN on sustainable development goals, the killings and armed conflicts in many parts of the world. I will conclude by considering, in relation to natural disasters and pandemics, issues of international legal process. Pandemics have long been the subject of general international regulation, with the broader matter of protection from natural disasters having only incidental regulation internationally. But recently that broader topic has become the subject of more comprehensive consideration at the international level, notably by the International Federation of Red Cross and Red Crescent Societies, the Institute of International Law, and the International Law Commission. The texts they have developed address major issues, and as I say, I will address them briefly. On the broader matter, according to a paper given by the United Nations Development Programme Administrator in 2012, over the past 20 years, 1.3 million people have been killed and 4.4 billion have been affected by disasters caused by natural hazards. 93% of the deaths occur in developing countries. Another UN calculation is that over the past 10 years, the economic losses caused by floods, earthquakes and drought amount to $2.5 trillion. A World Bank calculation is that every dollar spent on prevention, such as seismic strengthening, saves 7 lost. And that was the subject of the recent conference in Sendai in Japan. Disease causes much larger numbers of death, especially in the developing world. Malaria, for instance, kills more than 500,000 people a year, mostly children in Africa, and that's 1 child every minute. According to Bill Gates, epidemics and wars are similarly costly of blood and treasure, but only war is taken seriously by the politicians, at least in terms of preparations such as standing armies. The deaths from the recent Ebola outbreak exceed 10,000, and the World Bank calculates that the resulting harm to the three West African countries' economies is at least $1.6 billion. And some calculations of death from armed conflict would put that figure much, much lower than that for disease. Now, attempts to regulate the international spread of diseases, to turn to that more specific matter, have a very long history. Initially, control was exercised by local quarantine. The 40 days ships were required to be isolated before passengers and crew could go ashore during the Black Death plague. The latest international health regulations adopted by the World Health Organization in 2005 have their origins in the international response to the cholera epidemics in Europe between 1820 and 1847. The epidemics led to the International Sanitary Conference in Paris in 1951 and to the adoption of treaties requiring international cooperation in meeting the epidemics. The WHO took over the legislative role when it was established in 1948 and it adopted regulations in 1951, replaced them in 1969, but they required revision for a number of reasons. In particular, in recent decades, cross-border travel and trade have increased and communication technology has developed markedly. Just to take one figure, over the past 50 years, the numbers of travellers flying in and out of New Zealand has increased by a factor of 100. New challenges have arisen in the control of emerging and re-emerging infectious diseases. And there is the new information age in which news spreads via a multitude of formal and informal channels. The focus, furthermore, of the 1969 regulations was on just 3 diseases, cholera, plague and yellow fever, and did not address the multiple and varied public health risks that the world faces today, including, because this was in people's minds back then, as the new regulations were being drafted, disasters like Chernobyl. In addition, some unwarranted and damaging travel and trade restrictions had led to countries to be reluctant to report disease outbreaks promptly. Now, just to touch on some of the legal process issues arising in these 2 areas. Among them are 3 I mentioned. First of all, the actors. Who should be developing the rules? Should the people developing the rules be official or private? NGOs, as with the International Federation of Red Cross and Red Crescent Societies or the Institute of International Law? Should it be local or regional or international or all 3? Should it be in an institution with general or particular responsibilities? Second, the character of the rules. Should they be binding or be a model or a guideline? It's striking, for instance, that the very first sentence of the guidelines for domestic facilitation and regulation of international disaster relief, adopted by the International Federation, reads, these guidelines are non-binding. Similarly, the Sendai framework, which I mentioned a moment ago for disaster risk reduction, adopted just a few months ago, does not purport to impose legal obligations. By contrast, the international health regulations are plainly binding. One manifestation of that is that the Director General is required to deliver them when they came into force to the UN for registration under Article 102 of the Charter. And the third, after who should make the action, should the action be binding, the third matter, among others, is the relevant principles. The third of Lauterpart's characteristics drawn from De Jure Belli Ac Pacis is the affirmation of the social nature of man as the basis of the law of nature. That basic idea appears in the International Health Regulations Statement of Purposes and Scope. The purpose is to prevent, protect against, control and provide a public health response to the international spread of disease in a way which are commensurate with and restricted to public health risks and which avoid unnecessary interference with international traffic and trade. The principles set out in the regulations include, number one, the implementation of these regulations shall be with full respect for the dignity, human rights and fundamental freedoms of persons. Two, the implementation of these regulations shall be guided by the goal of their universal application for the protection of all people of the world from the international spread of disease. But Principle 4 emphasises the sovereign rights of states to legislate and to implement legislation in pursuance of their health policies. Against that emphasis, the regulations impose important obligations, some of them new, on states and the relevant international organisations of capacity building, notification, consultation and action, including the declaration of emergencies. The regulations can be seen in the much wider context of the work done by the International Law Commission on transboundary harm. And no doubt some interesting debates are going on right now and interesting reviews will appear of the handling of the Ebola crisis and possible improvements maybe in the regulations and in their administration. The clash that I've just touched on between humanitarian values and sovereignty has also arisen in the work of the International Law Commission on the protection of persons in the event of emergencies. The purpose of the first draft articles, which were completed just last year, the first set of the draft articles, is to facilitate an adequate and effective response to disaster that meets the essential needs of the persons concerned, with full respect for their human rights. The text also emphasises, affirms human dignity and humanitarian principles and places an obligation on the affected state to seek external assistance to the extent that the disaster exceeds its capacities. Assistance cannot, however, be provided without its consent. That requirement, said the Commission, is fundamental in international law. The draft does attempt a limit on the power to refuse. The requirement of consent, says the Commission, must not be arbitrarily refused. And in its commentary, it gives reasons in support of that limit and some indication of how arbitrariness might be shown. But it also records that some of its members were of the view that that qualified duty was not recognised in international law. The next round of comments by states and their reactions to the final text should make fascinating reading. Now, in this return to academic life, I've moved away from the confined role of the judge, where the judge is largely confined by the issues properly arising from the legal dispute brought to the court, by the evidence as presented, by the arguments made and the relief sought. Just how successful I have been in looking more broadly at our responsibilities and looking at structures and interconnections is for you, as for others to judge. But I have tried to emphasise both process and principle. I would like to add to the references to Grotius and Laudapart, one to Carl Llewellyn for his similar emphasis on the interaction and necessity of both aspects. What Llewellyn is reported as having said is that technique without morals is a menace, but morals without technique is a mess. Thank you for your attention.
Thank you, Sir Kenneth Keith, for your illuminating presentation. As we're going to proceed further, let me indicate to those of you who are standing that we have enough chairs on the other side. And if you,
there's one here.
or there, or other places. So if you prefer to sit, please let us take a minute so you. It's now my great pleasure to invite our distinguished discussant, Dame Rosalyn Higgins, to provide her remarks on his presentation. Please come to the board.
Well, thank you very much, Dean, for your introduction, which I've greatly appreciated. Thanks to President Damrosch for her words. Although Ken and I have shared so much at the International Court this last decade, I was told by the Dean that we were not invited this evening as a job lot. Ken Keith was a fine and freestanding choice. And then a much younger, upcoming person was sought, and the invitation to me followed. I begin by saying how much I've appreciated and admired the lecture just given by Judge Keith. As with all of his work on the bench, on the International Court of Justice, it was scholarly, deep in its thinking, intellectually rigorous, and taking a remarkable sweep through geography and time. I think we've heard this evening a real tour de force. I want to say at the outset that I fully agree with him that Grotius' work has to be understood in its context and by reference to where things stood at his time. And I fully agree also with Judge Keith on the importance of understanding the significance of wearing different hats in life and the relevance of that for law. Grotius, to whom we still frequently turn today, finds the rules he announces as self-evident. He was, all said and done, the originator of these great ideas, hitherto unknown, speaking of just causes only for war, but they cannot be found in treaties, customs, or the practice of states. His importance today precisely lies in how he articulated these thoughts, how he came to do so as the first to do so. I've long thought that to hold opinions and to make confident pronouncements that are not dependent on the ideas of others who've gone before, on information proffered by others, is indeed the mark of greatness. As the Cold War was showing its first signs of softening, Sakharov was allowed to visit London in a carefully controlled visit. I was among the lucky few invited to a private meeting to hear him speak. He had lived through long years of total isolation. He heard no views other than the state speak of the Soviet Union. He had no access to ideas in the world outside. He was not able to read works of philosophy or the developing ideas of human rights. All his information he was dependent on for what the state provided. Listening to him, I had a strong realization of how dependent I myself was for the formulation of ideas on what I was allowed freely to know. And from then onwards, I've always thought that greatness lay exactly in the ability to know right from wrong, decency from inhumanity, in almost total absence of information, facts, and ideas of others. And there has to be something extraordinary about a man who wrote in Latin in the early 17th century, who definitionally could not benefit from reliance on the source of international law, and who so holds our attention today. Grotius himself bases the ideas that he so firmly expounds and their underlying liberalism on natural law. But natural law is so subjective, so much in the eye of the beholder, but it all has to begin somewhere. I've long thought that to hold opinions, I'm repeating now what I've just said, and I'll turn one more page. Judge Keith has mentioned how Grotius having become involved in the great religious controversy over predetermination, Grotius was erected for sedition. He was imprisoned in Lowenstein Castle and there wrote important religious studies and works on Roman law and Dutch jurisprudence. And it was a few years after his famous escape in the tea just alluded to by Judge Keith that he published a Jure Belliac Pacis Book 3. And thereafter his life was an extraordinary literary output while forced to live abroad. In 1983, there was a great gathering of international lawyers in The Hague to commemorate Grotius's 400th birthday. And I had the great good fortune to be present. Among all the learned papers there given, I remember two things: a marvelous epic poem composed and read by Ambassador Pinto of Sri Lanka, these days recently the Registrar of the Iran-US Tribunal, recalling the life and death of Grotius at Rostock in 1645. The poem was rather in the style of Coleridge's Ancient Mariner, felicitously crossed with Tennyson's The Lady of Shalott, so you can hear the cadences. It was wonderful, and it imagines the reaction of the kindly innkeeper of Rostock to the gradual realization of the stature and genius of the sick man whom he tended in those last dying days. This wonderful person gave me a vicarious sense of pride in the fact that not international lawyers were Philistines. The second thing I so clearly remember is a service for 4 hours long in Latin and Old Dutch in a church of bone-numbing coldness. I remember Queen Juliana arriving at the church in the most enormous heavy fur coat, and my husband whispering to me, "I think she may know something we don't." How right he was. So we have to remember the context in which Grotius prepared his astonishing works, astonishing because of their originality and humanity. What can it mean today when we speak of Grotius as the founding father of international law, when we recall his insistence upon the freedom of the seas, believing fishery resources were infinite, and the limits to the authority of states to act entirely as they wish? Have not times changed so as to make the legal sentiments with which his particularly associated somewhat obsolete? Of course, the United Nations Charter contains many important clauses on the curtailment and limitations of the use of force, with that being limited, as everyone here knows, to self-defense. The road back from this precept to the idea of Grotius is a long one indeed, with many intervening landmarks, but the lineage is real enough, and the starting point on the journey merits brief recalling. On the lawfulness of resort to war, jus ad bellum, the forthright views of Hugo Grotius marked a break with the past and the beginning, I think, of the contemporary formulation of international law, which would change occasionally through time. He wrote in Book 2 of De Jure Beciat Pacis, "No other just cause for undertaking war can there be except injury received." He further elaborated 3 justifiable causes: defense, recovery of property, and punishment. It's evident that although this placed important constraints upon states, it didn't, of course, limit the use of force to self-defense as we understand it today. The Charter has a much more confined view, which was based at the end of the day on the idea that there would be a collective security system which would allow for these narrower definitions of lawful use of force. The reality is that the United Nations collective security system has, I believe, almost totally failed. The brief flurry of hope at the authorized military action to remove Saddam from Kuwait was short-lived. Since then, so-called authorized action as a means of blowing life into the collective security system has been fraught with endless problems. And in recent times, we now see regional action not fully authorized by a divided Security Council being the order of the day. The contemporary problem of humanitarian intervention is another difficult aspect. Also, in the Grotian view, humanitarian intervention could be a just war, and we all know that under the UN Charter, this is much harder to maintain, and whether the Charter forbids all such intervention has been the subject of much scholarly debate. In Book 2 of De Jure, Belli ac Paces, he declares, wars are justly waged against those who treat Christians with cruelty for the sake of their religion alone. Yet we know today that religious persecution abounds and that states, for good or ill, will not normally intervene, except perhaps where the lives of their co-religionists are in danger, or when the acts, and will know immediately what I'm referring to, or where the acts seem so vile that it is felt there has to be some response. But normally the will to act is not there, and worse still, different actions engaged in conflict have led to the protection of different protagonists by different members of the Security Council. There does seem to be today much greater reliance on regional actors, which also can be useful, but it can also be fraught with difficulties, I think, that are still unfolding. I'm going to make a couple of remarks simply in concluding now. It was very important for Grotius that a war be limited to the state. He has clearly written that bellum privatum is forbidden. It was, in his view, important to move away from what was commonplace at the time he was writing, namely violence between families, parties, cities. The limitation on the use of force imposed by Grotius' notions of bellum justum could only work if states asserted a monopoly over the use of force. Again, I fear the trend has been all in the opposite direction. One can trace a line from liberation organizations intertwined with the idea of self-determination to guerrilla warfare for political reasons, and more recently to non-state warfare for proclaimed religious reasons. So here there is a great problem. As Keith has pointed out, there are today fearful problems facing us that were utterly beyond what could have been imagined by Grotius. It is not, in my view, in accordance with the Grotian principle that these new and seemingly intractable problems, on which perhaps no definitive answer can easily be found in the accepted sources of international law, to proclaim a non-licet. The Grotian tradition does not suggest that we throw up our hands and say, there is no law on this matter. There are Grotian principles to invoke in resolving this dilemma, as Judge Keith has well pointed out. And dare I say it, if you embrace an approach to international law, which one has to agree, Grotius would have found very strange. if you embrace an approach to international law that emphasizes how to make authoritative decisions to achieve Grotian outcomes, then the battle is half won. Thank you.
Thank you, Dame Higgins, for your insightful remarks. The Nobel Prize winner of Literature, Gabriel Garcia Marquez, once said in a meeting for young leaders at the end of the 20th century, something perhaps relevant. He was asked, what could we expect for the 21st century? And he said, we cannot expect anything, just from the passage of time, except getting old, of course. But things happen when we imagine them and then we bring them to practice. The heart transplants and the Ninth Symphony were in the heads of their inventors before taking place. The idea of the Grotius lecture was creativity, taking the tradition and looking at context and values and principles, and not the mechanical application decontextualized from the world where we live. I think we have been extremely fortunate to hear, witness, and we will continue to study the insightful remarks of two important figures in international law that challenge us precisely to that, to capture the important message of Grotius. It's a message of creativity and discovery, and a message that assigns law and the rule of law an important task in that endeavor. So we're grateful for your presentation. Let me also say that we have to thank the ASIL President, Lori Damrosch, that is here to conclude this meeting, and the Executive Vice President and Executive Director, Mark Agras, for whom this is the first Grotius lecture in this capacity. We look forward to continue to working with him in many years. We will all witness already his creativity. Then let me also thank, from my own school, Professor David Hunter, who is the director of our International Legal Studies program, for this, the organization of this lecture, as well as Julie Yorkshire, whose technical support and commitment has been impressive. After we hear from the President of the Society, I want to invite you to join us at the reception. And I'm sure we all have enjoyed, as I have, these impressive presentations today. Thank you very much.
Thanks very much to both of our lecturers for really brilliant, really stimulating presentations, and to Dean Grossman for his wisdom in those concluding remarks. I just want to say on behalf of the American Society of International Law how grateful we are to the American University for its support of this annual Grotius Lecture, which each year is a highlight of our annual meeting. American University is one of over 50 academic partner schools that join with the American Society of International Law to sponsor programs of this type. We value these partnerships immensely. They give critical support to the Society. ASIL Academic Partner Schools hosted dozens of lectures, workshops, conferences, and career mentoring sessions over the past year. And so we want to thank all of our academic partners, but especially here today, our academic partner, American University. And then I have a couple of announcements. One announcement is please check your conference bags for the updates about the 3 additional events, including the plenary session, as I mentioned, on which Dean Grossman will be speaking. There are several other events there. We also have an app that you can download and find all this information electronically. And then the final announcement is to tell you the place for the reception, to which you are all cordially invited. It will be next door in the Regency rooms B and C. Hope to see you all there. Thank you.